Bos. Galaxy. Come.
Atomis of the states, Halo Hapa Yusha, Captain Ambrose Uma, and Honorable Vaughn in the legislature.
Please, Mr. Chairman. My name is Lukwago. I will be addressing this honorable tribune on the issue of the leadership of the team much later. But permit Mr. Chairman to introduce to you Council Ernest Karubara, Kiiza. I have Eron Kiiza. Nakora Kiiza Elias. Ronald Samuel Wanda, Chintu Mike, Kato Musine, Kakuru Musine, Sekanjako Abubakar, George William Nakura, Unihira Proskovia, Katushabe Ronald, Isaac Wagara, Kabiye Lawrence, Naroga Miriam, Faruku Kamlegea, Kato Wilson, Silas Ogur, Tukume Kepi Moses,
Deumba Robert Tumusime, Akakimpa Godfrey, Samuel Muyizi Mulindwa, Kijambu Gordon Mukisa, Alinitwe Peter. Now we have issues here with the retired Major Ronald Iduri, who is part of the legal team. But as you will be notified, Mr. Chairman and honorable members, we received some disturbing news this morning that he was abducted in the wee hours, and one of our colleagues will substantiate on that because it's a matter of concern for our legal team. We also have Edwin Kafura, Bowe Alfan, Apollo Katumba is here. And before you are 3 visiting jurists. That is Margaret Nangapovi from Angola. And also, Kisheru Kilemo from Kenya is a visiting jurist. And Mr. Chairman, last but not least, our team leader, the Lady Council, Martha Mangari Karua. Mr. Chairman, there are 2 issues we really need to address. One about the seating arrangement in this court, because the way we are seated, and I can't even say we are seated, some of our colleagues can see, they can't execute their duties effectively under such circumstances when they are standing. And we need to confirm from time to time on how to deal with the matter. So with that housekeeping matter which we hope have been addressed prior to the commencement of the proceedings, unfortunately, Mr. Chairman, you can see we are really disjointed the way we are seated, and we needed to act as a team because we have all been instructed to deal with this matter. So I request, Mr. Chairman, that you be pleased to direct that matter be addressed. The second issue, Your Worship, is in regard to Mr. Chairman, is in regard to the Lady Council. Last time we appeared here, we had kind of a note that their processes we are still pursuing, Mr. Chairman, regarding her practicing certificate to be able to have audience before this honorable tribunal. It's actually in that account that this honorable tribunal deemed it necessary to have the proceedings deferred to allow us that time to finalize the process. Where we stand today, the status quo has not changed, Mr. Chairman. There are matters which are still before the Law Council. We have gotten a communication from the Law Council which we would like to share with you, Mr. Chairman, and the response has been made by the senior counsel here. We are waiting their pronouncement of the same or further processes, because we feel this is a matter of great concern to not only the accused persons, but also this honorable tribunal, given its centrality on the constitutional processes in this country. Mr. Chairman, I don't need to delve so much into the provisions of Article 28. Actually, read together with Article 23, the right to fair hearing, and the cornerstone of that particular right part of it is indeed effective representation of the accused persons. And the accused persons have got a prerogative, which is constitutional in nature, to choose lawyers they deem competent enough to deal with their matter. And under Article 28, this Honorable Tribunal is enjoined to facilitate the accused persons with all what they require to be able to prepare their defense effectively. And one of the tools they require to effectively prepare their defense is to have a formidable and competent team duly constituted. So in a nutshell, Mr. Chairman, we are still in the process of having our legal team fully constituted, because right now our legal counsel has not been cleared by the law council, and there are few issues that have been raised by the law council, one of which being, Mr. Chairman, the need to prove that there is value addition she's going to make in this matter, and that will prove that indeed her presence in this matter is critical, is important for effective dispensation of justice. We intend to do that because it has been one of the key issues raised by the law council. The other issue they raised that they have no precedent of this nature where it's been a cross-border practice in criminal matters. That in the history of this country, all the jurisprudence we have never had a single criminal case attracting a lawyer from the foreign jurisdiction. That is something which is equally fundamental. We want to establish whether indeed representation by jurists from a different jurisdiction is restricted to civil matters, because that is a contention within this ruling of the law council. And finally, Mr. Chairman, the question of East Africa integration. Mr. Chairman, allow me, with your permission, Mr. Chairman, I just want to prove to court that the Honorable Karua here holds an East African passport, which is a valid document in Uganda.
I think Council of Work, we are going to go into those issues. We already the news about the decision of the law council. You tell us the way forward, we are just going to how we are to the next thing.
Mr. Chairman, I wasn't advised that the court had read newspapers. So it's the reason I was laying the foundation. For this case, I thought the court acts on evidence, and I wanted to submit this to court for record purposes. And with all due respect, I don't know which newspaper.
That being the case, we have talked before about started. And even we have agreed that she has to be given a seat, but she will not participate in the proceedings. So if you are the one leading the team, proceed about the case.
Precisely the point I was making, I have not been instructed to lead the team. The instructions to lead the team remain with Karua. And that is the point I very much wanted to put on record to guide the proceedings. And with your permission, allow me to submit this document, together with the response given by the Honorable Karua. These documents, for record purposes, the response is here. Mr. Chairman, if you may, for record purposes. So the long and short of it, Mr. Chairman, as I sum up my submission, the accused persons are still in the process of constituting their legal team, and this is what we are still dealing with. And it's an inalienable right, a non-derogable right under our constitution, that they must be accorded the right to a fair hearing. They must be accorded facilities to be able to adequately and effectively prepare their defense. So we are still at that stage, Mr. Chairman and honorable members. I beg to submit. So I will let my colleagues, Mr. Chairman, add on, because I mentioned the abduction of retired Major Iduri and a couple of other issues. I beg to submit, Mr. Chairman.
Thank you, Mr. Chairman and members of the Royal Tribunal, the military tribunal. On the issue of
Council Kiiza, if you read the UPDF Act, we don't have the word tribunal in the UPDF Act.
the English meaning of tribunal is court.
You read the Act, what does it, what is court?
Judge advocate, you are not supposed to exchange with me. You are not a member of the court. You should advise it and they tell me. You are not a member of the court. You advise court and court rules.
Listen, my advice to this court is final.
No. You are not a member of court. He is not a member of court.
The law is clear.
I must read the section 169 of the
Read it.
UPDF Act
Read it.
and section 212.
Read it. Read it.
You read that, I'm
No, read
directing
it.
you.
No, you can't direct me. You are not court.
Council
My friend.
Kiiza, can you listen?
We have rules of this court. It is not going to be like a political rally. Read section 169 and section 212. We don't know about that.
I'm sorry about the interruption.
You wait, they read for you the law, because you may end up in the wrong hands of the law today.
Even you may end up there.
Just listen and they read for you.
Order, please. Order, please. First listen to what the judge advocate is saying, and then we proceed.
I can read for you if you don't have the law. No, I have my book. You know, this is a court. I don't want to hear the word tribunal because it is not under the UPDF Act.
See, that is guidance that only comes from the
Listen.
court, members of the court, not from a judge advocate.
Listen, Kiiza, section 212, witnesses and advocates at military courts. And I will refer you to subsection 9. Any conduct of an advocate before a unit disciplinary committee or court martial that would be liable to censure or be contempt of court if it took place before a civil court is likewise liable to ensure or is contempt of court in the case of a unit disciplinary committee or court martial, and the provisions governing the procedure of unit disciplinary committees or court martial are binding upon an advocate appearing before unit disciplinary committee or court martial, and willful disobedience of provisions shall, if persevered in, be deemed to be in contempt of court, punishable in accordance with section 169. So go to section 169. Two twelve, subsection 9. Then section 169, offenses in respect of military courts. I take you to 1G. Any person who, being an advocate, conducts himself or herself in a manner described in section 212, subsection 9, will have committed an offense and is liable on conviction to imprisonment for a term not exceeding 5 years. So, as you address this court, I'm just giving you another warning that you must read the law. We are in court, we are not on a rally.
Whatsoever he has read, he cannot in any way determine what we advocates for the defense say. We are not under his command, and no can he determine what court decides.
No, you can say it, but be orderly. You are not going to submit a
because you try to dictate what counsel should say on our behalf, and you not have that right.
So can I read to you the rules? I'm the judge advocate of this court, and I'm the one responsible for making sure that everything moves on procedurally here. You cannot be a judge in your own cause. That's why we're in court here.
There is a judge in this case. They are the investigator, arrester, prosecutor. Judge, what are you talking about?
Where do you get those facts?
Do you want to surprise the facts of abduction? Do you?
So,
Do you want to surprise them?
Kiiza, you can go ahead and submit.
Okay,
I've given you the law.
Thank you. So, we are talking. Can I have the mic, please? Before the route. What's going on? What is working here? Yes, thank you for the guidance that the defense lawyers are working. So, Honorable Chairman and members of this military tribunal, we have 3 issues which my senior land counsel alluded to, but I will start with the abduction because abduction is a derogation of Article 44, Paragraph C of the 1995 Ugandan Constitution. It is a sacrosanct right that should be not so. I'm not talking about the abduction of the accused persons from Kenya to Uganda and their concomitant incommunicado detention, which has resulted into this proceeding. What I'm talking about is that a member of our defense team, retired Major Iduri Ronald, has been abducted this morning towards 5 a.m. and he's not able to represent Dr. Kiiza BESIGYE and Haji Rutale Obied Kamleje. And that means we are unable, our hands are tied. Our team is incompetent. Even if it was complete, there's a lot to say about that, but we want to note that we feel that this is a form of intimidation on the legal team. The last time I appeared here in the morning, I found soldiers on my office. I ignored them because if they had touched me, I would have beaten them. But there are some members of this team who don't want any association with soldiers around their offices, around their homes. Major Idurona didn't open the door for them. They broke the door and he left the phone on, and his siblings could hear the wreckage reminiscent of the abduction of Kakwenza, how it unfolded. So we hope this Honorable Military Tribunal can rein into the conduct of the military so that we don't have a repetition of this unfortunate development whereby a member of the Rotary and the BESIGYE defense team is arrested for precisely doing their work. If Iduri had not been arrested, he would be here with us and would be in a much better shape, including even on the knowledge of the rules. Because Iduri, I started practicing with him for this Honorable Military Tribunal in 2014. I have been around. We started in Kasese, we were in Wundubujo, we were in Jinja, and I'm an old hand at this. We have 3 visiting jurists, and one of them is seated here on the front because she's the team leader. She will not speak, she will not submit when eventually we get to trial, but her right as senior counsel to sit on the bar is untouchable. Then the seating arrangement, your Honorable Chairman and members of this military tribunal, we are unable to proceed with any further when our colleagues are standing, because there is no way we can proceed in this fashion. We pray that this Honorable Court sorts the seating arrangement of our colleagues before, as a defense, we can proceed any further. Thank you.
Mr. Chairman, for records, my name is Luyimbazina Lukola. I rise to express our displeasure as regards the manner we have been treated at the entrance. When we enter here in these premises, we are supposed to be officers of court, and we should be treated as such. However, after here, we go back when we don't need any further gym, any further work. After here, we are so tired. As we talk now, we are extremely tired because of the mistreatment the soldiers take us through. This should change. Indeed, there is nothing which resembles a court, depending on the conduct of the soldiers out there. Mr. Chairman, it is my humble request that this honorable tribunal benchmarks with the other courts, allow us the permission to treat it as a court. Indeed, the way we are treated, we are right to say that we and our clients are being persecuted. Our clients are not being prosecuted, but rather persecuted. Your soldiers out there are determining who to lead us, where to sit, who speak what. Indeed, we are not grateful with that kind of treatment. This is not what is done in courts of judicature. Something must be done, Mr. Chairman. As you lead by example, that example must be seen. That is the motto. By example, we lead. That is the UPDF motto. But sincerely, there is nothing to emulate from the conduct of soldiers out there, treating us as if we are criminals, as if we are convicts. We are not. We are good people, and we love you guys. We love you, soldiers. Don't treat us like that. Tukoye. Thank you.
Maybe registrar Honorable Chairman, let's sort out the issue of representation. How many people filed instructions with you? Because
It's okay, let me handle. Honorable Chairman, and can I speak? Can I speak? No, Raphael, what's your problem?
They have asked the registrar, not Kiiza Eron.
I'm requesting to speak.
No,
I'm not imposing
the
on
judge
myself.
advocate has
No, have you suddenly become a court of
Why are you
affairs?
volunteering?
we want an answer from the registrar of the court.
Mr. Chairman. Mr. Chairman, I request we respect the rules regulating court processes. When an advocate is instructed, they have a right of audience. Each of us here were instructed to represent their chosen persons. So even if all the 40 were to speak, they breach no law. So I kindly and humbly request the judge advocate to hold the fire.
No, the issue is we want to know who filed the practicing certificate with the registrar.
But the thing is,
How
we
are
have put the names on record
We
of
want
those
the-
who are supposed to have audience.
We want the practicing certificates of every advocate appearing here, and it is done even in civil courts.
Please, order, please. Honorable Lukwago, I wanted to talk about that in my just small communication here. When you talked of sitting arrangement, from what the registrar has, he told us 10 people who have fulfilled the requirement. And that's why the arrangement is like that. We expected 10 people, and those who have not fulfilled to be in the seats behind there. Why? First of all, Councillor Lukwago, you are safe. You did what you are supposed to do. Others did not do it. Now, what is that? Why is it like that? Why is it like that? So Judge Advocate was asking the registrar to update the court. How many people or who are they who fulfilled the requirements? Can you please tell us that?
In prayer, in arrest of that, of the Registrar General's thing, reading of the list, because there is a constitutional matter now at play, the right to a fair hearing. The last time I checked, Uganda was being governed by a constitution. In section 2 of that, article 2 of that constitution, it was binding on all authorities, all persons, including the judge advocate, including this court, every member, and it is to the effect of that constitution that the right to a fair hearing is sacrosanct. That right to a fair hearing includes the accused persons, in this case, our clients, choosing their lawyers, the number of the lawyers, and even now as we speak, they can add on the number of lawyers. It is not the province of any court in any land, not even the Supreme Court can tell the accused here.
Councillor Kiiza, we are not limiting anybody. We are just talking about the procedure.
I am trying to say that that procedure, to the extent that it tries to stop BESIGYE from hiring a new lawyer right now and submitting it before you, is null and void. And the solution to such a null and void notices is in several provisions of the Constitution. There is 274, and another one is 1262. The 1262 says that substantive justice, and there is no justice more substantive than the right of a lawyer, the right of an accused to choose their lawyer. And that right, when I say it is sacrosanct, I mean it cannot be modified by anyone, not even the President of the Republic of Uganda can modify the right to a fair hearing. Right now, even as we are speaking, we can substitute counsel. As we speak, we can get a new counsel. So the idea of 48-hour notice, we reject it as null and void. Family, we are not, the fact that me and Lukwago brought a notice does not mean that we are amending the constitution of the Uganda. That was a bonus, and since the accused have since added on the lawyers, and you, no one can tell the accused which lawyers to appear today. That's why we are unable to proceed without our colleagues.
But you know,
Mr. Chairman, if I can proceed, maybe if the issue before this tribunal is about whether one qualifies to be an advocate and to have audience before you, it should be clear, and I have my practicing certificate with me here. I can provide it to this court. Two, I raised on an issue that is very clear. Under the Constitution, the formation of the UPDF, and Article 208, I will go to 2, that the Uganda People's Defense Forces shall be non-partisan, national in character, patriotic, professional, disciplined, productive, and subordinate to the civilian authority as established under this Constitution. We form part of the civilians, Mr. Chairman, and the tribunal. 2, clause 3 is that members of the Uganda People's Defense Forces shall be citizens of Uganda and of good character. Mr. Chairman and your tribunal, the character depicted by the members at your entrance there is not of good. Secondly, I can see you have your name tags on your uniforms,
I think,
including
sir,
these people.
Those issues, I don't think that's why we are here. First of all, we are sorting out the issue of advocates.
Yes,
Honorable Lukwago said people are standing. You are taking us astray.
Advocate Judge, let me address my issue, then you can respond.
No, because
after.
that issue,
Because this is a very sensitive issue.
Councillor Lukwago has talked about it.
With all due respect, my issue is a different issue. It's about identification of the people that you put at the center as we enter. You can't know who manhandled me, who battered me, and you should act as good examples to the rest of the people. You are people with superior powers to guide the professionalism and conduct of your people. Why can't that be sorted so that we know who is addressing us and at what time by putting on their name tags on their uniform? I thank you.
Councillor, you have heard about the conduct, and I have heard from your side. I will interact with those people at the gate who are manning the security. I believe that one will be solved.
Registrar still, you have BC. I don't think anybody is going to put on a suit and a tie and come here and say I'm a lawyer. So we are going to prove that by a PC. If you don't have a PC filed with the registrar, we shall not recognize you in this court.
Mr. Chairman, we take exception to that. Lawyers certified to appear in any court once they are on record. So if you are in doubt whether one has got a PC, that can always be addressed. But it's not that every time we come here, we brandish our PCs. Here it is, here it is, here it is.
Councillor Lukwago, we have not asked you. There are those who have not submitted.
No, this is exactly what we are saying.
Okay, no, anyway, let's settle the issue. So there is what we call a digital system in the court. Even if you want to know the lawyers who are entitled to practice, you can Google them on the Uganda Law Society website. They are public, are available. That should not be a problem. It's not a problem of the accused. I think whoever is trying to create that problem should deal with it, but the accused has chosen competent lawyers, and whoever is in doubt of their qualifications should Google them.
And for any doubt, they can proceed to the local council for those holding out.
Kiiza, he who alleges must prove. Listen, I'm alleging that you are
In the unfortunate
If you are saying you are an advocate, you have to prove to us we
No.
want a PC, and it is not
In the-
negotiable, by the way.
Pardon? In the in the-
as we are being searched, as we are entering this courtroom. So we cannot provide several times. How many times are we going to provide?
The ball is in your tribunal.
Then the answer without being with the judge advocate saying, I have scrutinized the chief registrar by the letter, and the letter, the list is submitted, saying this one and this one are not enrolled. That is not so. It is not him suggesting who is an advocate. Because he does not hold the role of advocate. He does not.
I don't hold it, but I am moved governing the court.
Not the certifying authority to certify whether somebody's PC is ready or not.
Anyway, the matter is simple, and my guidance is final. If, I'm telling you, you have to file your PCs with the registrar. That is it.
No. Mr. Chairman, we would do, Mr. Chairman, we would wish to hear the pronouncement of court on that, whether the interpretation by the judge advocate is final and is binding on this court and on all of us, whether it is ill-advised or not, whether it is misconceived or not. We need to get a position on that, because otherwise that would be a violation of the principles of fair hearing, because we are here to be heard by the tribunal and a decision made.
But for avoidance of doubt, we do not need to hear from the chairman to know that the judge advocate is misleading court. The primary character, the defining feature of any tribunal, including quasi-judicial tribunals, is judicial independence. If a tribunal is telling us that it is not independent, that whatever the judge advocate says, they will swallow it hook, line, and sinker, then we have no business here.
Getting the word tribunal. We don't have a tribunal here.
I don't know how many times I will tell you that this is a military tribunal. There is a dictionary, you can look it up, the meaning of tribunal. I'm getting tired.
Council Chiefs, sit down. I think, Council Lukwago, we are not doing this honestly, because I don't see what harm does it make you to follow the procedure and bring your PC and the instructions to registrar, so that we know people we are dealing with. What's wrong with that? Why do we waste time on this?
Because, Honorable Chairman, we have put it in black and white. We have put ink to paper. We have.
And you are tasking court to find out, to go on Google and find out whether you are practicing or doing what?
In the cases, just a minute. In the cases where
you all came from your farms. Why didn't you come with a copy and file with the registrar?
So, Chairman, in cases where the court doesn't want to Google, they formally write to the chief registrar of the courts of judicature, and the chief registrar writes back indicating that this person is not enrolled or licensed for this year, or he is. That is how the procedure for courts that was their sort to do.
You talked of Major who was arrested or abducted.
Retired Major Iduri was abducted a few minutes towards 5 a.m. this morning by members of the joint security team, including the military, to which this military tribunal belongs. And that's why we are using the good offices.
It's good you know who arrested him. I think you can either approach them or pressurize them to produce him to court, so that you can start from there. Otherwise,
Our complaint, Your Honor, is that, Mr. Chairman, is that he is a member of the defense team. The reason this team is incomplete is because he has been abducted by members of UPDF.
And that's what I'm saying. It's good you know who arrested them. Members of UPDF, I think, many departments. I don't know who arrested him. Is it the court or is it the... Who arrested
It's
him?
not the court.
Who arrested
They are like
him?
the ones we met there without tags. The guys we met at the gate, they are also like them. They are without tags. Some of them are... Yeah, it's a nasty situation. Your Honor, when abduction is terrible.
Since you know them, that one you can handle.
We are military strangers. We just know they are military men, but they are not identifiable.
If he's brought here, then we will listen from you. And Councillor Lukwago, you again talked about the lead council, Madam Karua, I think. Yet. Who is not cleared by the law council, according to the document you have presented here. So before she's not cleared, I don't know what you have. Can you read the team or not?
Chair and honorable members, I unequivocally stated that the prerogative rests with their chosen persons to choose who leads the team. But from the instructions we got from council here, the law council, if I may read page 3 of page 6, paragraph G, the law council is composed of members who have full-time jobs in other government agencies and as private practitioners. They require adequate notice in order to meet and consider applications. We believe they have not had ample time to canvass all the issues they needed to deal with, given that statement. So it would be premature for any decision to be taken at this stage before we exhaust all these processes. We believe the law council, in making that statement, they wanted to get more time to deal with this. Never mind that they indicated some issues which we find objectionable, like the political connotations and other matters, which we can put squarely to them. And as I indicated earlier, Chairman, the Honorable Martha Karua has made a strong rebuttal to all the issues that have been raised here, which has been served on the law council. We are yet to be favored by a response. We believe now that there is a rebuttal and the issues they were raising have been adequately responded to. They are going to reconvene and take an appropriate decision. So this is, we are saying, on the understanding that the accused persons have got a right to constitute a legal team to defend them. The right to legal representation is sacrosanct, is non-derogable. That is the whole point. And they want to have an effective team. And these are not the usual proceedings we have, Mr. Chairman. Because if it was just an ordinary case where you are trying a matter which does not cut across different jurisdictions, Mr. Chairman, the charge sheet is very clear. The accused were picked from a totally different jurisdiction, Kenya, and they were brought here without going through the due process, without an extradition order, without a deportation order. So the jurisdiction where they are picked from is where you are having the senior counsel coming from.
And that is the reason we find strange the reasoning advanced by the law council that they don't expect any special skill the senior council is going to bring onto this matter. Maybe they were oblivious of these facts, but now that there is a rebuttal, we are confident that they are going to reconsider this matter. So I cannot arrogate myself the duty of lead the council when the instructions are on the contrary. I thank you, Mr. Chairman.
It's okay, Council. If that process is finalized, for us, we are here. I saw you as if you wanted to say anything. If it is not there, Registrar, you can give us a date.
Chairman and court members, I want to make a comment before I make my prayer. How my colleagues are behaving. One of the complaints that was raised was that the lawyers are mistreated at the gate. And I'm not at the gate, but from my own observation, when you look at our colleagues, how they are conducting themselves before this court, and when they are now confronting those younger boys, what do you expect? If they can behave the way they are behaving when they are here, what about those small boys? So the approach must change. Their approach. Then my prayer to this court is that, which council is saying is not court, but from the act, it is a court. It is a court martial. It's not a court tribunal. My colleague, Councillor Lukwago, has been appearing on so many media and discussing the merits of this case. This court has no jurisdiction. The charge sheet is from the other. I think it is bound by the subjudice law. Matters before court should not be discussed. And I've seen him several times, including Eron Kiiza, who is referring to this court as criminals. My understanding of criminals.
Can I substantiate myself?
No,
it is you to sit down. When I
Please.
raise, if you are a lawyer who went to law school, sit down, don't waste our time. If I stand up, you sit, it is automatic.
I went in
it's
the law
automatic.
school before you.
No,
I went in the law
that
school
is okay.
before.
Then
Please,
you didn't learn it before me,
I seek protection.
No.
When they were talking, I kept
You
quiet.
see, when a lawyer
Let Jesus
stands
quiet.
up, you sit automatically. You didn't learn that in school.
Council Kiiza, why don't
No.
you be patient? He submits and then you are given time
Yes,
to
but
also to
I
answer.
gave you time to talk.
You don't just mention Eron Kiiza for her. No. Stay it up. Stay it up.
I think you are possessed.
Council Kiiza.
Yes, I'm possessed of wisdom and knowledge.
You are possessed.
Yes. Yes,
Let
I'm
me-
possessed. I'm happy you recognize it.
Kiiza, can you listen?
We were taught in the law school that if you are an aggrieved party, you know where to take your complaint. You don't just move to the media or go to the pastors or witchcraft. And I do believe that Council Kiiza Eron, you know where you are supposed to take your grievances. Why do you take them to the public? No, I'm addressing court. Why do you take these complaints to the public? Why don't, if you are an aggrieved party, you know you are supposed to go to another court. The other time you appeared here, you first made press-ups outside the court. And I don't know, sorry, why are you killing this profession? What explanation do you give to your children? Were you taught the 5 years you were talking about? Were you taught that you must first make press-ups before you go to court? You come sweating, you are in a tie sweating, and my understanding is that after an exercise, you are supposed to take a shower. You come when you are in that sort of state, and you say, you studied law for 5 years. I quote the act, you call it rhetoric. You come, you say it was amalgamated. So, please try to avoid those actions that you are doing. Come when you are composed and when you are prepared to proceed with the matter. So I pray that these people be restrained from talking about the matter which is before court. You can see some, I can really recognize some revered lawyers. I've not heard him talking, and I think he's waiting for evidence. But some people come here just to make a show. Ernest Karibara is here. He's a respected lawyer. I've not seen him making any noise, trying to show up. No, he's waiting for evidence, not a show up. So I pray that these lawyers be restrained from discussing matters, especially touching evidence. So if you go with the charge sheet to the public, so what will the public do? They are going to advise you to go to the pastors, to the witch doctors, and that could be the direction. So in regard to my Lord Chairman and court members, in regard to the abduction, I wanted to clear this issue of saying this person was abducted, and no, we are not having the person before here who was abducted. The legal process was followed. There is East African protocol allows us to enter into various arrangements and engagements. And among those engagements, there is a memorandum of understanding between the Republic of Uganda and the Republic of Kenya on cooperation in defense and security matters. And under that arrangement, it is where we have the two accused persons before this court. There is a paragraph 3.
Objection.
What are you objecting? And who are you?
I am objecting to your conduct. We are not yet at that point. We've not sorted out issues raised by counsel. Can I have a copy?
Can I have a copy?
What you're stating.
No. It is a private. It is a memorandum.
Then stop wasting our time.
Not waste our time by
If it is
proceeding.
private, don't waste our time.
No.
Don't waste our time. Either you share it or you sit down.
Kenya is not a failed state. You can't simply go there and
No, we need a copy. No, we need a copy of that nonsense.
But you can see even this conduct here. This conduct of these lawyers here, young lawyers.
We are objecting to your conduct.
Look at how you are conducting yourself. So I was saying that under this arrangement, that is the paragraph 3, subparagraph 4. So, my prayer is let those who are involved in this matter be restrained from discussing this case, the case before this court in the public. The validity of evidence, the charge sheet is defective. The charge sheet, if the charge sheet is defective, you know where to take it. It's not the public that is going to rectify it. No, you can see. Is that a lawyer asking that question?
Yes.
Yes.
Yes, please. Yes. It's a valid
So,
question.
my Chairman, I pray that these people, they restrain from this. It is, the subjudice law is very clear. A matter before court should not be discussed in the public. And they know it.
Mr. Chair, if I may.
We have a response to the application. It's frivolous and vexatious, Mr. Chairman. It has not in any way been grounded on matters of law. I believe he attempted to submit on issues of sub judice. I hope he had come adequately prepared to make reasoned submission on that particular matter. Because there is a wealth of authorities on the rule of sub judice, and he has not cited any of the authorities or a principle or anything. But if I may help him on this, the rule of sub judice, Mr. Chairman, is not absolute. It's structured in such a way that one shall not discuss a matter which is before court in a manner that is likely to prejudice the outcome of the case. It is qualified in a manner that is likely to prejudice the outcome of the case. That is one. Two, to discuss a matter which is before a court of competent record, a court of judicature. If matters are before a disciplinary committee, for example, they are before a tribunal, they are before an LC court. I'm not suggesting this is one, and I don't. I request you take it in good faith, Mr. Chairman. I'm just giving examples. So the rule of sub judice is not of universal application. It's about courts of judicature. So if it's a matter which is before the General Court Martial, which is not a court of judicature, which is not a court of competent record, he ought to have come prepared with authorities to stretch the application of that rule to the proceedings here. And I make those submissions well advised that they are good authorities to that effect. We are not expecting him to raise it. But that said, Mr. Chairman, again, the rule does not bar anyone, not even advocates, not even members of the public, to discuss decided cases. He talked about our continued pronouncement of the trial of civilians before the General Court Martial. There is a court decision to that effect. So it's not a matter which is sub judice, whether civilians should be tried before a General Court Martial or not. It's a decided matter. If he interested himself in the decision of Kabaziguruka, a copy of which Council Tugume can show him, we have a very big decision. It is there, a huge one, about that. So if we are interpreting a decision of the Constitutional Court, we are not breaching any rule of sub judice. I am at liberty at any given moment, any given time, any given forum to interpret the decision of the Constitutional Court. I breach no law. What is pending before the Supreme Court is the appeal. So if I make a demand that the Chief Justice should render a decision which has been long overdue, with the commitment that was made in a ruling that I can share with you, I have a copy here, Mr. Chairman. You get me a copy here. I am breaching no rule whatsoever.
So if I read out, and these are things these are matters we have said time and again on media and elsewhere. And this ruling here, Mr. Chairman, in the Attorney General versus Honorable Michael Kabaziguruka, the Right Honorable Chief Justice here and the justices of the Supreme Court, in decision number 4, they said, owing to the matter in contention for which the appeal has now been filed, being one of great public importance, the appeal shall be accorded urgency and shall be immediately fixed for hearing, dated the 5th August 2021. So, Mr. Chairman, when we stand out in the public and demand that the Chief Justice should honor the dictate of this ruling, the decision they made that this appeal should be disposed of expeditiously, we are actually asserting the rights of Ugandans in the Bill of Rights in Chapter 4. Because matters touching the Constitution, matters touching personal liberties, rights, take a precedence over any other matter. So these are the issues we have been discussing, and by now, the point I wanted to emphasize, the position of court now, which has not been set aside, and which we can freely discuss, is that this honorable court has no jurisdiction to try civilians. That is a decision of the Constitutional Court, which has not been set aside. So if I repeat it, I'm breaching no law, and no court can stop me from saying that. So that is as far as that issue is concerned. The other issue is talking about, and the last one, is about, again, matters in the public domain. Mr. Chairman, we are really shocked that the prosecutor here is talking about the defense, when indeed actually the application should be in regard to the state. The application to restrain any of the parties in this, indulging in the merits of the matter, actually that order should be directed to the state. Why? Because they have already started trying this matter in the court of public opinion. Getting audio clips, which are purportedly said to be emanating from UPDF, being even transcribed verbatim in one of the dailies here and a number of other media houses. This is prejudicial to this matter. Actually, it is choreographed to condition the public out there and the international community that these accused persons here stand guilty. Contrary to the foundation of our Constitution that thou shalt not be treated as a convict until proved otherwise. Now the state is already trying them in the court of public opinion. And he has not come out to condemn that and to ask any application for court to restrain them. What a shame. So, Mr. Chairman, I want to conclude by asking that those issues he's raising shouldn't be entertained here. What needs to be done at this material time is for us to have the team of lawyers, because we are still considering the preliminary matters. Those are the preliminary matters we raised. We want to constitute our team fully and be able to proceed with the matter as and when we are ready to proceed. So I beg, Mr. Chairman, that the application he has raised, and to me in particular, you see, he mentioned my name, and I wish he cited anywhere where I featured and offended the rules, but that is besides the point. But if I may also ask him, as I conclude, Mr. Chairman, is he asking for orders to restrain debate worldwide? Because this matter is not only restricted to the confines of Uganda. It is on CNN, on Al Jazeera, on AFP, on KKNT, and it is everywhere being discussed. So, of what I don't know, the confines of the orders, whether this General Court Martial has got orders to order the world never to talk about Dr. BESIGYE case until a decision is rendered. So that would be really outrageous, with all due respect. It would be absurd, and it shouldn't be entertained. I beg to move, Mr. Chairman.
I will be very pithy, and I like the wondering that raise these matters. One, media has media freedom. We are not going to discuss it. If people didn't understand it, it's too late. Pastors, going to a pastor is a function of religious freedom. It is outlined in the Constitution. It's a human right inalienable. Going to witchcraft, if I wanted witchcraft, I would have gone to Raphael. I didn't. Where to take grievances, yes, I know. Press-ups, I want to be healthy. I don't want to look like some people. About the profession, yes, I'm an honorary member of the profession, and on civil society, the Uganda Law Society has recognized me. About rhetoric, now we can't get into poetry. We are here to discuss law. So I still leave the rhetoric to him. The word promulgated means bringing into effect. Laws are promulgated. I don't know what the... I mean, I am not responsible for the inability of the prosecutor to understand what I'm saying. I am not responsible. There are some things that, on prayers of restraint, that one I will not dignify it with a comment. On prejudice, he needs to address himself to Article 29 of the Constitution before he submits on prejudice. He hasn't. Has he? No. The charge sheet, yes, it is a public document because there is an assumption that a quasi-tribunal is a public body whose documents can be shared. We shall continue sharing charge sheets in WhatsApp, with media, on my Twitter. It's even there. You will not remove it. And we shall debate it. Abduction, it is a fact. You can't rival it. You abducted. The people here, these two people are a product of extraterritorial abduction and extraordinary rendition. Those are the English terms. If any breakdown is needed, I am ready. These are victims of abduction, of heinous kidnap. They are here because some soldiers committed crime in Kenya on 16th of November. Those soldiers have not been brought to book, and tomorrow I'm going to write to the CDF to give me names of the criminals who brought BESIGYE and Rutare here in a breach of Kenyan law, of Ugandan law, and East African Community law, and the African Charter on Human and People's Rights, and the Universal Declaration of Human Rights, and the International Covenant on Civil and Political Rights, on the Convention Against Torture, and other legal instruments. Raphael will not stop that. That's a discussion between me and the CDF. It's above him. Kidnap, abduction are crimes under the laws of Uganda. No member worth his salt, no citizen of Uganda should be here to drum support for kidnap and abduction. The duty of anyone who has witnessed abduction in community detention is to report to police or appropriate authorities. This should be the last time that someone is rising in this court, in this military tribunal, to support abduction. We should all condemn it. The memoranda he was trying to read is a secret. There is no law which is a secret. Laws must be gazetted. Whatever you're reading is null and void. Yeah. Indeed, these are older men. The last time I checked, BESIGYE was around 68. Rotary was crossing nearby. And so if you are going to hold old men standing for these hours as lawyers urge the law, or what looks like law, it's going to be unfortunate. I mean, what looks like in the case of Raphael. It is also unjust that our colleagues, we have raised it, we are unable to proceed further because we cannot proceed when our colleagues have nowhere to sit. It vindicates those who say that this is a kangaroo court. Kangaroo means unfair in case someone doesn't understand it. And I know who will not understand it.
Mr. Chairman, in just 2 sentences, Mr. Chairman, I will have ended my submissions. Mr. Chairman, the prosecutor is inviting you to restrain our freedom of speech without any evidence, without any justification, without any basis. He is blackmailing us, Mr. Chairman. I believe you have heard from his statements, attacking even our conduct from outside this tribunal, Mr. Chairman. For instance, when he cited the press-ups which were made by my land friend. Mr. Chairman, I invite this tribunal to treat his submissions as mere statements from the bar. The same should be disregarded as being without procedural or evidential value. Mr. Chairman, overrule the prosecutor. Mr. Chairman, don't grant the orders he's seeking. Mr. Chairman, the prosecutor is inviting you to infringe the provisions of the Constitution. Mr. Chairman, you and your tribunal must uphold the provisions of the Constitution. Mr. Chairman, we are not at that level where we may be considered to have moved against the principle of res sub judice. Mr. Chairman, I beg that you disregard all the prayers made by the prosecutor. I beg to rest.
Mr. Chairman, with all due respect to the state here, I made a comment about the discipline and how we are mistreated at the entrance. And he claims that it is because of our conduct, which is not clear. We are told to identify ourselves. We do identify ourselves before we access these premises. This is a public court. As we speak now, you can look at the men here in uniform without name tags, even when the space is provided for. We are here, they have introduced us. You have name tags on your uniforms. Why are they here? Our security here should be paramount as a public place. That should not be an issue of Council Raphael to discuss here. It should be clear and court with all its powers, the tribunal. Through you, Mr. Chairman, you should make that order and a directive, and it should be complied with so that we ensure that we are secure and safe even when we are speaking in this. Thank you.
You are very secure, Council. J.A., anything? Anything?
You want to make a rejoinder?
My Lord.
My Lord Chairman, honorable court members, we have a brief rejoinder, especially what was raised by Land Council, Mr. Lukwago. My Lord Chairman, in as far as the jurisdiction of this court is concerned, but two, my Lord Chairman, also on the, we rely on the decision of the Supreme Court.
Have respect for counsel on the other side. If there is an objection, you should listen.
ni Joseph
Listen,
Tushabe
objection.
against the
Please
Attorney
sit
General.
down. We are raising on a matter of objection. You know the procedure.
It's a 2005 decision.
Objection, objection. Please sit down.
And my Lord Chairman,
Sit down.
it's my
Sit down.
It's my humble prayer that
Sit down.
General Court Martial is a court of judicature.
Objection.
No, ours was to sub judice. We are discussing sub judice and legal representation.
Much obliged, my Lord Chairman. I was saying that we rely on the decision of Tumshabe Joseph against the Attorney General. It's a 2005 decision in as far as
Why don't you allow him to proceed? You quoted Kabazuguruka. He also has the right to quote a
In
case.
regard to sub judice,
much obliged,
it
my Lord
was in
Chairman.
regard to the issue of sub judice.
And my Lord Chairman, with due respect to my senior colleague, I pray that he be restrained because I wouldn't want to exchange with my senior. I have a lot of respect for him. But be as it may, my Lord Chairman, I was submitting that one, we ran the decision of the Supreme Court, the Tumshabe Joseph versus Attorney General. It's a 2005 decision in as far as pronouncing itself on this court. But also, my Lord Chairman, on the decision of Kabaziguruka, my Lord Chairman, we have a ruling which I think
Please stop taking us on a wayward voyage of self-delusion.
And my Lord Chairman,
Objection, we are objecting. When we stand up, we sit down.
and my Lord Chairman, if I may read verbatim as part of the ruling in that
Objection.
What is
my Lord Chairman, I pray that
Objection.
my Lord Chairman,
Objection, Anthony, objection. How can you get tired?
No, but you talked about courts of judicature. And Tumusali is about courts of judicature. Now what?
We are not Mr. Chairman, if you allow me the latitude, our defense team is not fully constituted.
Audience.
So we have no instructions to proceed in respect of substance of this matter until when our defense team is fully constituted, Mr. Chairman. All we can seek is to have maybe this matter adjourned to another date or any other business, but not concerning this matter. If the prosecutor is withdrawing the charges against our clients,
We have no problem. We shall oblige, Mr. Chairman. I thank you. But we cannot continue discussing or submitting on the substance of this matter. It's premature. I thank you, Mr. Chairman.
Thank you, Council. The issue is this. They raised discussing court matters in media. Then the Council submitted. And I don't know what, if state that's what we are going to make a rejoinder or
Yes, that's
on
true.
that one so that
That's true.
court can rule on that.
Mr. Chairman, it's all clear. Mr. Chairman, he was there in two other matters because what he submitted on here was about the application was making rescuing us to debate this matter in public, and we responded.
Yes.
Now he's raising new matters which were never canvassed in the application, and for which we have no capacity at this material time to handle before we deal with the question of representation. Yes. That's what was discussed.
So state if you are
No,
making a
he is the
rejoinder
one
on that one.
who raised the issue of Kabasugurka. We have not talked about it. But now when he raised the issue of Kabasugurka, we have to respond.
I think you abandon that. Make a rejoinder on objection on the issue raised.
Mr. Chairman,
And then we rule.
Mr. Chairman, before he makes a rejoinder on whatever, we need to sort out, excuse me, we need to sort out the issue of representation before we go any further, because we have no instructions to proceed beyond this point.
Bisaka and state pray for a date, and we have the matter adjourned because they are saying they are not ready to proceed. Council Lukwago, do you have a date or state proposes? A date, yes. State, you propose a date.
Can we have it mentioned like in a week's time? In a week's time, we go and pursue our other matters.
There was a ruling, so can we receive the ruling before we go?
The prosecutor is failing to understand us. We have no instructions to proceed beyond this point until we have sorted out representation of the accused persons. If that is difficult to understand, I will use vernacular.
Council Kiiza, please.
What have you come to do here?
Council Lukwago, do you think a week will be enough for you to
What have you come to do here today?
have finished? A week will be enough for you?
Like 10 days, Mr. Chairman. 10 days. Let me consult him.
I think, sir, since the case is still the state's case, they should be the one to propose a date.
Mr. Chairman, if I may, with all due honor, my name is Tugume Ronald. I want to apply to be a friend of this court, having seen the dilemma we find ourselves in, all the way from the judge advocate, senior prosecutor, and what the defense is going through. I want to apply to be amicus curiae in this matter.
because there are some constitutional issues and human rights issues, and it is on that basis that court can admit us to be amicus curiae, so that we can resolve the unwarranted procedural issues that are engaging us wantonly at this moment. I pray.
Honorable Chairman, we cannot respond to that, and we are not interested in any ruling on that. For us, we have no instructions to proceed on anything before we conclude the issue of representation, whereby our lead counsel must be Martha Karua from Kenya.
We vehemently object the application of having amicus curiae.
Your Honor, my Lord, we cannot proceed with that, not even with objections. We need the issue of representation sorted out first. The accused have a right to a fair hearing. We pray for... Chairman, we are praying for 1 week from now.
The case is a state case. They are the ones to apply for the date.
And I do believe even when you are given 1 week, you will not be prepared. We pray that the case be adjourned to the 7th of January 2025. For me, 7th January 2025.
Mr. Chairman, we know how we are conducting ourselves. Mr. Chairman, we request that we be given a 1 week's adjournment, and we suggest 17th. Reason, Mr. Chairman, we are talking about civil liberties of the accused persons, and also we have processes to pursue before the law council involving the lead council here and others, so that we have them expedited and come back here on the 17th. We move on to another stage. So to talk of 7th January, I think our land friend here wants early Christmas.
No, Council, I think let's give you enough time, because it seems whenever you come, now you come with other excuses. Get enough time, prepare yourselves, and then we proceed. I think 7th January is enough for you. And with that, Colonel retired Dr. Kiiza and your colleague, your case is adjourned to 7th January 2025 for further mention.
What time, Mr. Chairman?
The same time. 10.